Yep. This is the planning board meeting for the city of New Brunswick for December 9th, 2014.
Roll call.
Larry Barber,
Here.
Kevin Jones, Betsy Garlotti, Dave Fitzhenry,
Here.
Joe Catnese,
Here.
Jeff Crum,
Here.
Carly Neubauer,
Here.
Josefa Rojas,
Here.
Andy Kaplan, Linda Hunter,
Here.
Suzanne Ludwig.
Here. Public announcement, Open Public Meeting Act.
Please be advised that the notice requirements of the Open Public Meetings Act have been complied with and satisfied, and that the annual notice will give sufficient notice of the time, place, and conduct of all public meetings of the planning board of the city of New Brunswick has been filed with the city clerk and placed on the appropriate bulletin board in the lobby of City Hall, 78 Fire Street, New Brunswick, New Jersey, and has been transmitted to the official newspapers of the city of New Brunswick, namely the Home News Tribune and the Star Ledger.
Please stand for a salute to the flag.
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Minutes of the board's November 18th, 2014 meeting.
Madam Chair, the members received copies of the minutes in their packets. Unless there are any changes or additions, motion to approve would be in order.
There's actually one correction that should be made on page 5. Mr. Credible asked me if I was the mayor's campaign treasurer, not manager, campaign manager.
I'll make that.
Motion to approve with correction.
Second.
All in favor?
Aye.
Aye.
Opposed? Minutes passed.
Old business, Construction Management Associates, PB 2013-25, site plan and variance application for the construction of a residential building located at 17 Mine Street, Block 71, Lot 4.01, zoning district R-5A, and redevelopment area 2. And I believe we have some preliminary matters before.
Yes, Madam Chair.
We do. Madam Chair, if I may. At the last hearing, I believe one of the members of the public had commented that this was a new application. I don't know whether I'd use the words new application in responding to that individual, but I want the board to be clear. Mr. Catnese was also, had also at that time answered the question of the member of the public in indicating that this was in fact not a new application. I want to reiterate to the members of the board that this is not a new application. The application was filed some time ago. This is a de novo hearing of that application. A de novo hearing means that you are hearing testimony anew, fresh testimony. So the board members, as have been instructed in the past, will disregard any evidence that was presented by way of testimony prior to the de novo hearing of this application beginning, and that was in October.
Yes.
However, any documents that were submitted as part of the application packet and any documents that were subsequently submitted as a result of the application being heard by the members of the board since October, and the testimony that was provided after the de novo hearing are what the board members should consider. They are not to consider any advice that they may have received from prior counsel.
Thank you.
The second matter, if I may, is also in terms of the application and any documents that were submitted. And Mr. Patterson, did you want to address that initially?
Yes, thank you. Madam Chair, in the staff, in going through the large box of documents related to this application today, notice on our checklist of completeness for the application that had been checked off that the environmental impact statement had been received, but we were not able to find a copy of that statement in the file. We're not 100% sure if it had been misplaced or had not been received and inadvertently had been checked off. In any case, we are asking the applicant to submit a environmental impact statement to us so that we would have this available prior to the subsequent continuation of this hearing into January. Discuss this with board counsel. as to the status of not having this document previously, and we also looked in Cox, New Jersey Zoning and Land Use Administration, and the Cox book is very clear. This is not a jurisdictional issue, that the completeness checklist is there for just starting the clock on when an application has to be heard. So it does not require that the application be started anew, but it is important to have it so that the applicant and public can judge the full scope of the application. So we're in contact with the applicant and advised them that they needed to submit this at least 10 days prior to any subsequent continuation of this hearing, so that people would have a chance to review it properly. And then we'll have the full, complete application. Cox is also clear that the board does have the authority to hear applications that are not complete.
Madam Chair, just to confirm what's been identified by Mr. Patterson and council, that was brought to our attention, and we will be providing an environmental impact statement more than 10 days prior to the next hearing date, assuming that this carries over into January, which I think that date, at least for now, is January 13th, so I believe it's 5 weeks from tonight. Our expectation is that would be submitted within 10 business days of today, and I will be providing a copy of that to the objector counsel so that he has that in sufficient time. But it is our intention to submit it as per the request.
Okay, thank you. And I believe we're going to start with the objector's presentation tonight.
Madam Chair, I'm prepared to proceed. I have some things I'd like to place on the record initially. I prepared to cross-examine witnesses, and also I'm going to present witnesses of my own. I would note first that there were members of the public that were lined up to speak. Now, certainly I want to get going tonight, all right? But I think part of the reason that the public was going before I began was so that my cross-examination, my presentation would be more streamlined. I wouldn't want a situation where somebody were to say something and then I would have to start cross-examining the witness based upon what they said. So perhaps at the outset, if we could get an idea of who remains in the public, wants to speak, and how much time they want to stay, then we can probably make a decision. You know, because if the idea is, well, it's going to be a few minutes, then why not let them go, and then I can be more streamlined. And but if it's going to be 3 hours, then I think we have to discuss that, because I'd like to get that.
Madam Chair?
Yes.
The order and conduct of the meeting itself is within the discretion of the board chair and the board. I appreciate council's offering to poll whether individuals from the public wish to go ahead of him. However, that's strictly within the province of the board chair to determine who the next person is, unless council is indicating that he does not wish to be heard. I would humbly also submit to the board that it's pretty difficult to tell someone who wants to say something, a member of the public, that they're now going to be limited to whatever time they say they are. Nothing is precluding members of the public who wish to be heard at some point after the objector's presentation to present whatever additional statements they wish to make. Indeed, I would propose that perhaps it would be more prudent to allow them the benefit of listening to the objector's case, and that may make their points even more clear, more salient, or more pertinent.
I agree. I prefer you start with the...
That's fine, Madam Chair. I just know that that was the situation last time we were here. I want to clear that up. I would just like to reserve further comment, argument, perhaps cross-examination, or the like, after those comments are made by whoever wants to speak tonight. I'd like to begin my presentation tonight by placing a procedural objection on the record based upon what was just said earlier tonight. I do agree with your attorney that it's important to define what type of application this is moving forward, and more importantly, how that impacts the record going forward. And I do agree with your attorney that this is not a new application. It is not a new application based upon the 3 applications that are in the file. Throughout, it's been called seminary housing throughout. The basic purpose of it has always been a 4-story apartment building, although was certainly, it was reduced somewhat in the last amendment back in May. But the bottom line is that it is not a new application. It is a continuation of the old one. Although, what has happened is that the applicant chose to essentially redo the testimony, back in October. But, but then they knew I was going to object to and I placed those objections concerning Mr. Buca on the record about reconstituting the board. So, while I agree with the fact that it's not a new application, I disagree with how the record's being handled here. Because if it's not a new application, I think the entire record of this proceedings, testimony, all the documents, I think everything has to be considered. There was significant public comment, particularly last April, before I was really involved in this matter. And that should be considered too, because those folks may have chosen not to come to any more meetings, thinking that they had their piece, and now that apparently is not the case. So there's quite a bit of support in Cox concerning what the record is and what the purpose of it is, and I would cite counsel to the 2013 version of Cox, section 30-1 and 30-3. We can't draw a line in time, I think, at this stage between a time before and a time after the October hearing, because if respectfully in doing so, you're potentially arbitrary, capricious, and unreasonable. I talked about the April 14th testimony. We've talked about the documents in the city's file. I did hear what he said this evening about keeping the documents that were as part of this application from the beginning in. Because I would have said, well then, if we're not counting everything that was in before, then we don't have an application at all. Why are we even here? But there was a letter at the last hearing that was completely unrelated to this matter, but it was submitted for the purpose of citing a legal standard. Okay, that letter was dated 5/27/14. That's before October. Okay. Then there was a discussion about what the RSIS standards were. You wouldn't allow one of the objectors to utilize Mr. Olivo's report, which was dated the 2nd of January of this year, even though tonight that was changed yet again. So my point is, Madam Chair, you can't pick and choose here, respectfully. It's either everything is in or nothing is in. And if nothing is in, then this hearing's got to be adjourned and a new application filed with fees, notice, etc. It has to be consistent with what is presently before this board. And I'd like a ruling, please.
I'm sorry. May I ask if the chair can ask counsel if he can cite to a case for that proposition that requires a hearing that is a de novo hearing? I know that he cited to 2 sections of Cox, but in both of these sections of Cox, I'm at a loss to find any case that is specifically on point.
Do you have any case law that supports your argument?
I looked, Madam Chair, but I don't think there is any case law. The reason for that is I don't think it's ever happened before. Respectfully.
If I may, Madam Chair, on behalf of the applicant, may comment. Perhaps it is a unique situation, but we have to look at the equitable principles here. The reason that the applicant was forced, if I might, to proceed de novo had nothing to do with any action on the part of the applicant. One of the objector interested parties in this case has filed an ethics complaint against board counsel for participating in the previous testimonial proceedings. That's not the fault of the applicant. It wasn't caused by the applicant. It didn't have anything to do with the applicant. Yet, council is suggesting that the applicant has to start all over again with a new application, pay new fees, forfeit all the efforts that went in previously because of matters that had nothing to do with the applicant. It's a matter of attempting to look at this in a way which best serves the public interest and to remove the potential of taint that's not being raised by the applicant, that we frankly don't agree with, but is being raised by a member of the public. So I think the applicant shouldn't be put in a position where they have to be punished for having an objector raise that type of issue. So I think by doing what has been, how we've been proceeding de novo, is an attempt to eliminate the potential for any of that, quote, taint that Mr. Buca's participation in the meetings may have created by taking that testimony away and starting the testimony over again. The documents submitted, the application form, all of that as required by your ordinance was submitted because we're required to submit those, and those documents, forms are still valid and really support our application efforts. But to remove the, quote, taint of Mr. Buca's participation involves what transpired at the hearings, which is the reason we wish to start de novo. It also is because during that time, the application plans were significantly amended. So there was a need for all of our professionals to testify again anyway. So it was a logical way to proceed. I think that absent any case law that directs us otherwise, we ask the board to look at the principle of fairness here in an effort to, as best we can, cleanse the record to allow the applicant to proceed in a manner which he's entitled to as an applicant and for reasons that weren't caused or in any way directed by the applicant themselves.
And that objection was, that he speaks of was not created necessarily by my client either. But if you're talking about the public fairness, then the April transcript should be considered by this board as part of its decision because of it was an entire night, if memory serves me, and I haven't looked at this transcript in a while, but I will tell you what I remember is that it was all night long, it was the public. So if you're talking about fairness, if you're talking about equity, and fairness to both sides, then this, at a minimum, this should be considered. Although my argument is, as I've said before, is that everything should be considered.
Well, once again, one of the issues with that is some of the commentary, and no one's trying to minimize the public's ability to comment and re-comment and re-comment, but they were commenting on a plan that's been substantially changed in any case. So no one's keeping the public from an opportunity to speak. If what I'm perceiving here from the last meeting, this meeting, they'll be speaking more than once. So I believe fairness directs that we proceed the way we have been.
Madam Chair, at best, I would say that this is, the objection would be form over substance. At worst, it's doublespeak. And let me address the second part of that first, why perhaps this is doublespeak. As counsel, Mr. Kelsos pointed out, the applicant did not put himself in a position to require the de novo hearing of this application. It was because of members of the public that objected to the participation of that application by a professional, by one of its professionals, and the subsequent removal of that professional that required that. Now, the reason I say it's doublespeak is because we are now in December, almost the end of the year. We've now had 3 meetings on this. This is the first time this objection has been raised by counsel. Counsel has had an opportunity since October to raise that. As a matter of fact, in October, when I had indicated that the board was not to consider prior testimony, nor would they consider any advice that they received from Mr. Buca, counsel was present and did not raise that objection. I would say that he's effectively waived that. Certainly he can preserve that for any appeal should he choose to file a prerogative writ. The form over substance argument, or the recommendation that I make, is that even if a new application has been filed, brand new, had been filed a couple of weeks before that first October hearing, the board would still be the same board, would still have heard, and you can't unhear something, so to speak, all of the prior objections and all of the prior testimony, and would still be admonished by me as the new replacement counsel that they must disregard it. That's why I colloquied the members of the board in the October hearing to make sure that each member of the board would be able to set aside what they had heard before, and if they felt that they couldn't, give this application a de novo hearing and fairly render a decision based upon what they hear now rather than what they heard before, that they should recuse themselves. Members of the board candidly indicated that they could, in fact, hear the new. So, again, that would be form over substance here. With all due respect to counsel's objection, my recommendation to the board is that we go forward with the application. There is no merit to that objection.
With all due respect, Mr. Hinkle, this was raised because of a dialogue that you had had with Mr. Kentney on the record last hearing. I would not have raised it otherwise. I could not have raised it prior to that. Be that as it may, I'll move on. I'd like to cross-examine Mr. Broder, please.
Madam Chair,
Yes.
before we have that witness cross-examined, if I may inquire, the board may inquire of counsel whether there are any other objections that he has procedurally so that we don't have to face every hearing with a new objection. It could have been raised initially.
Do you have any other procedural objections?
Madam Chair, I do not have any other objections at this time.
Thank you.
May I proceed?
Yes.
Mr. Broder, is there a written agreement with Halei or an organization related to Halei for CMA to provide housing at 17 Mine Street for students or others affiliated with Halei?
Are you referring to Hillel?
Hillel, sorry.
No.
Is there a written agreement with Rutgers University for CMA to provide housing at 17 Mine Street for students or others affiliated with Rutgers?
No, there is not.
Is there a written agreement or written agreement with any educational institution, such as the seminary, for CMA to provide housing at 17 Mine Street for students or others?
No, there is not.
Are you aware of any contract that between DEVCO and CMA to provide housing for either Hillel or the seminary?
A contract with DEVCO to provide housing for Hillel or seminary does not exist.
And are you aware of any contract with DEVCO and Hillel to provide housing for students?
Not that I'm aware of, no.
And are you aware of any contracts with DEVCO and the seminary, the Rutgers Seminary, to provide housing?
Not that I'm aware of.
In your application, you've indicated that you plan to use the first floor apartments for the dedicated for the New Brunswick Theological Seminary. Is that still the case?
Correct.
And the upper three levels are open to the public.
Correct.
So the majority of the units are non-seminary, correct?
Correct.
And open market means basically whoever you can get, correct?
Correct.
You could have families,
In theory.
and seminary students may have families,
In theory.
and families may generate a different parking demand than undergraduate students, correct?
Absolutely possible.
And when did your company purchase this property?
We do not own the property at the moment.
Okay, you had development rights assigned, correct?
That is correct.
Okay, when did that take place?
A year ago in December.
So that's December of 2013?
Yes.
Okay. What were the condition of the buildings when you bought it?
The houses?
Yes.
I believe they were pretty similar to what they are today. Abandoned, relatively run down. I think they were boarded up, partially at least.
When did DEVCO purchase the property?
I couldn't tell you that.
Don't know. Okay. So your testimony is that the condition of the buildings is the same today as they were when you obtain those development
From
rights?
when I recall driving by a year ago to driving by today, to me, they look relatively similar.
You had testified that you did not want this development to provide unsightly surface parking. Is that right? You recall that testimony? And isn't putting, or potentially putting cars on Mine Street that is already, maxed out with parking, wouldn't that be unsightly too?
We're not proposing to put any vehicles on Mine Street.
Despite the fact you're asking for a variance that is basically half of what the RSIS standards require.
Our proposal is for on-site parking. We are offering to give up our rights to off-street permit parking. Permit parking is enforced pretty strong in New Brunswick. So this would be a matter of the market demand. We've got 20 years' experience doing this with similar properties, and our track record has proven that the model works. The amount of parking that we typically provide, the number of units, and the number of vacancies relative to what we have has been what we call a sweet spot. We've found the balance, and it works.
Now, you've never developed on Mine Street previously, have you?
No, we've developed mere feet away. Virtually all of Union Street has been redeveloped because of our efforts.
In October, you testified that you contract with a towing service to control parking on the site. Is that right?
That's correct.
So in other words, if there was some interloper that came in and they're sticking around, you would get a towing truck to get rid of them, right?
If someone is parked illegally in one of our spots, then we would have it towed, yes.
But that same authority does not go to move parked cars on the streets, correct?
No.
The car share agreement, I think you said it was with Enterprise.
Correct.
Is that terminable at will, that arrangement?
Well, again, the arrangement has just been discussed. It's not finalized. I mean, we're waiting to get final approval before all the details are sorted out, but it can be terminated if we choose to, yes.
Is it possible to not have it at all?
If we choose to not have it,
Yes.
I would imagine, yes. But if we agree to do it as part of the condition of our approval, then that's what we will do, and we'll live up to our word.
And that takes up a space, correct?
Correct.
So it's 42, not 43.
Correct, but we've presented testimony that one of those car shares is equal to as many as 15 cars, so we're actually adding spaces in our view.
In October, you testified that there were important union construction jobs that were being created by this development. Can you tell us what that is, what they are?
Well, if we ultimately build the building, we will have union construction workers on the site.
What unions?
I'm objecting to this. What is this relevant to the application?
I'll move on. You testified that, going back to the car share, you had said that, just give me a second. For the record, I'm quoting from page 105 of the transcript from the November 18th, 2014 hearing. There was a question, a couple of questions that were put to you by Mr. Anthony Larabina. And the testimony went as follows. And if I can ask the applicant, is this enterprise car share going to be solely for the occupants of the building? Mr. Mitchell Broder, it has not been contracted yet. Mr. Anthony Labrina, okay. Mr. Mitchell Broder, we need to get through this first, and then we contract with enterprise. We are talking about a process which is about 1.5 years to 2 years away. Mr. Labrina, so it is possible that it could be publicly used by everybody else at Rutgers. Mr. Mitchell Broder, that is absolutely possible. And if it is, and if we need more spots, we will provide more spots. Now, my question goes to, what do you mean by providing more spots? More parking spaces on site?
Well, first of all, we should all understand that this is the first time that anyone is proposing to do this in the 6th Ward. So this is a new concept. We are open to it operating in either fashion, whether it was available to members of the public or just people that live in the building. So for the record, if this board would be looking to us to commit that it would be only for members of the property who live there, unit owners or renters, we would agree to that.
So,
Madam Chair?
Yes.
If I may, procedurally, if council is reading from a certified transcript, perhaps we should have that marked and introduced.
I think we're up to 04. I'm smart.
That would be 04. Do you have an extra copy of the transcript from November?
I can provide it. No, this was, I have an extra one October.
That's November transcript?
Yeah, it's the November 18th, 2015. And it's on page 105, 16 to page 106, 106. 106.
Madam Chair?
You need a copy?
Yeah, if council is also going to refer to the other two, I think the October, I'm sorry, the other hearing, the October hearing, perhaps we could just mark that as well at any point,
Sure.
just as a, so we get out of the way now.
05 for
05?
October?
05 for October. All right, so the answer is then, that I think I heard, was that you wouldn't be providing more spots. So that testimony that you gave at the last hearing was somehow incorrect?
No, when you say we wouldn't be providing more spots.
Actually, you said that.
No, what I'm saying is, we would provide spots as needed for the enterprise car share. So if enterprise requires one spot, we will give them one. If we require two, we'll give them two. And you may ask, well, what does it mean to require two? If the demand is such that we need to have more than one enterprise car, which is a good thing, because that means people are utilizing the service, then we'll provide two.
What if those spots aren't available?
The spots will be available because we control the spots.
Because there are no spots available on Main Street, correct?
Sir, this is a spot that's inside our property, not on Main Street.
So how does car share work? You said, so will this be open to the public or not?
Well, right now, we're trying to get through an approval process. We haven't ironed out every exact final little detail. We've gone to great lengths to amend this project significantly in response to the public comments that we've heard throughout the past year. And you're asking me about finite details of this car share program, which is, again, a new concept to the city. But from my understanding so far, and in my discussions with Enterprise, the way it works is a person joins the car share via a yearly membership. They're given like a pass code or key of some sorts. There's an app that they can use on their phone to reserve the vehicle for certain times, certain days. And apparently through their phone they can program in and have access to the vehicle and drive off and go do their errands or whatever they need to do and then bring the vehicle back and put it in the spot.
Is it always a round trip?
I couldn't answer that question. I would imagine that the concept is that the vehicle does not drive in one direction and leave the vehicle there, the person wouldn't be there.
Well, is it possible it can be driven to a location which also recognizes car share? That's my question.
Again, this is new, so you're asking me details that you may want to call Enterprise about, but the car share program is provided by Enterprises to leave a vehicle in that spot. So if that vehicle is driven to upstate New York and left there, then another vehicle from Enterprise would be brought to the location, from my understanding of it.
And how would you know to bring another vehicle there?
How would I know? I'm not under the pressure Enterprise does that. Yeah, these are all things that we're doing, innovative things to help the process, to make the process better. We're not telling you that we have the magic wand and we're solving everyone's woes. We're just providing answers to problems and trying to make them better. So that's what this is, one piece of the pie.
So are there limits on time? Could it be 1 hour? Could it be 10 hours?
I couldn't tell you the exact answer. I believe you can use as long as you want. It's payable by the hour.
So if the car's gone all day, it's conceivable that somebody could get frustrated, decide maybe to bring their own car along on site, correct?
If they have a spot to park their car, then they will bring it to the building. If they don't, they can't park it on the street. They have to go to the lobby,
Or they'll park on my street,
and they'll get to it.
but not by your people.
No. I'm sorry. They will get ticketed by the city of Brunswick.
That's all I have for Mr. Broder at the moment. I'd like to cross-examine the architect. Can you pronounce your name again, sir? I want to be sure I get it right.
Shock.
Shock, okay. Mr. Shock, on Vine Street, the style of the architecture of the homes that are there, would you consider them Federalist or Victorian?
There are a number of different styles that are embodied in the homes that are on Main Street. Some probably have Federalist type of details. There are some that have Victorian details. I don't know that there are pure styles of any of them, but I'm not trained as an architectural historian either.
But they exist. And this building is neither, correct?
This building is neither.
Okay. So then it's not in keeping then with the redevelopment plan. Wouldn't you agree?
No, I don't agree with your statement. The redevelopment plan specifically guides new design to use elements of style that are present in the neighborhood as a way of connecting new buildings to the visual continuity of the neighborhood that's embodied in both the specific and the general guidelines of the redevelopment plan. That's exactly what we've done, and I previously testified to.
But there's no elements of Federalist or Victorian architecture.
Not specifically.
Not specifically, thank you. And you presented an exhibit, I believe it was A3, which just shows pictures of the derelict properties on Vine Street. In fact, there's many properties on the street, including my clients that are right next to this, proposed development, that in fact, keep well-maintained properties. Isn't that right?
The photographic exhibit was not of every property on Main Street. That is correct.
Okay.
I do not believe I testified that they were derelict. The purpose of that exhibit was to show the types of styles and the mix of design features that are there.
But suffice it to say that A3 certainly did not show well-maintained and well-kept properties. Correct?
I'm not sure that I would necessarily agree with that. I think that some of those properties are reasonably maintained.
If the materials that you're using in this building, if the materials, the scale, if it doesn't mimic the older homes on Line Street, it's not harmonious with the neighborhood, is it?
Because there's a variety of ages, styles, materials, rhythms, scales, proportions, sizes of all sorts of materials along the homes of Mine Street. I would disagree with your statement. In fact, that it's not intended to mimic a particular design. It is intended to use appropriate details so that the scale and visual appearance is consistent.
But does it mimic the language of the redevelopment plan?
I don't understand your question. The language of the
I'll move
redevelopment
on.
plan.
I'll move on, sir. The homes that are on this property, on this street, most of them are 2 stories, correct, on Mine Street?
There are quite a few 2 stories. There are some that have a occupiable attic area, 2.5.
But there's nobody's got a 4-story building like you're putting.
I don't believe there's a 4-story. I believe there's 3.
And there's no apartment buildings presently on Mine Street, correct?
Not to my knowledge. I don't recall. If there's, by apartment building, there are multifamily dwellings.
I'm not talking about multifamily. I'll
But that's a
clarify.
definition of apartment building. It's how many dwellings you have in a building, regardless of what it looks like. So by that standard, yes, there would be others.
Other than multifamily homes that are on the property, this would be the only apartment building that has in excess of 50 units on Mine Street?
To my knowledge, yes.
And this is the only redevelopment property that is on Mine Street, correct?
Area 2 of the redevelopment plan includes this property, but I believe it also extends to property that fronts on the opposite side of Mine Street.
And this is the only redevelopment property in the RA5 zone?
Of that, I'm not sure.
Okay. Did you review the redevelopment plan as part of your testimony on direct?
I did.
Okay. And doesn't that plan call for, it says that new buildings were appropriate, should strengthen particular urban design features of its locale. It talks about framing a view corridor. Do you recall that language in the plan?
I don't recall that specific language, but do you have a particular reference?
Yeah, it's on page, it was on page 19, 1H, I believe.
Counsel, do you have an extra copy?
No, sir. It's on page 20 of 30.
Counsel, just so we can be clear on this, why don't we mark that as 06, the redevelopment plan, which is comprised of page numbers, 39 pages, I believe, 39, just from my copy.
H on page 20.
Yes, I see it.
Okay. Won't this building, if it's built, block the view corridor of 15 Mine Street from south to north of the historic buildings and the church steeple at the north end of Mine Street?
I don't believe that it will. you would have to look at a specific view corridor, and generally the view corridor and what is discussed in the redevelopment plan talks about the pedestrian experience at Mine Street, not the depth of the lot.
Yet it's your testimony with a setback that is closer to Mine Street than exists for the properties that are next door at 13 and 15. It's your testimony that your building will not block views.
It will, I don't believe it will totally obscure the views. So you're correct. The building is positioned closer within the permitted setbacks of the redevelopment plan. It is closer than what exists now. To that extent, it will, from certain vantage points, have a visual impact.
How many people could live in this building if it's built?
With the, I'll have to refer to one of the exhibits.
Sure.
I'm not referring to a marked exhibit, I'm referring to the planning board architectural drawings that were submitted with the application. On cover sheet CS, there's a table marked occupancy, and it lists a total of 124 as potential occupants.
And that's well in excess of the density which exists in the neighborhood of the 1 and 2 family homes, and the occasional multifamily homes, is that correct?
Yes.
And at the October hearing, you testified that this building was shaped like an H, is that correct?
Generally, yes.
Okay. And there's no other buildings on Mine Street shaped like an H, correct?
Not to my knowledge.
Okay. If the building were reduced to 2 stories, wouldn't that be more compatible with the redevelopment plan?
No, I don't believe so. The redevelopment plan specifically calls for an FAR of 2.5 on this site. It specifically allows for 40 feet in building height. And it specifically calls for additional density and more intensive development than what may exist. The design standards talk about how to handle that density so it's more appropriate. It doesn't say not to do it.
When you testified in October, you said that the overall area dropped of the building when you stepped it back, using your words, from 54,000 square feet to 52,600. And you testified that was a significant reduction in square feet, correct?
In my opinion, yes.
So the square footage as proposed today is approximately 97% of the original square footage. And that's a significant reduction?
I believe so. Because the square footage allowed we were still allowed with the prior. What we've done is we've reduced square footage, reduced mass, reduced scale in a way to better fit into the neighborhood in response to the earlier testimony here.
Now, when you stepped it back, stepped the 4th floor back, you didn't do another shadow study. You're not aware of one, did you? Or anybody on your team doing one?
We did not introduce a shadow study into our presentation. Is that your question?
There was a shadow study that was done previously, but it was not done. It was not done again, correct?
It was not done again because the building got smaller. It would have had less impact as a smaller building.
Now, you stated this would be a typical non-gated garage, correct?
That's correct.
And theoretically, anyone can enter and park if they can't find a space on the street, correct? Nothing preventing them from doing it.
There's nothing physically preventing them from doing it. However, management will enforce their rights.
You indicated that if you were to stand across the street from Mine Street and look at if this building were built, and you could see the 4th floor from across Mine Street, is that right?
You can see the cornice line of the 4th floor, correct?
Is it your testimony that the step design that was done, is it your testimony that will not affect the light and views of 15 or 13 Mine Street?
Not specifically the step design. Any construction will affect light and views. That's true of any construction, regardless of how big it is. The step design, what it does is allows for greater light, greater views than would otherwise be if we fully built out as was originally proposed.
But we don't know how much though, because a shadow study was done.
No shadow study has been done for this.
Okay, you also testified, Mr. Sharp, that you were talking about wall dominant roofs and less dominant roofs. And the surrounding buildings on Mine Street are less wall dominant than the proposed building. Would you agree?
Restate your question one more.
The surrounding buildings, the surrounding residences on Mine Street are less wall dominant than the proposed building.
If by less wall dominant you mean that there's less wall, that's certainly true because this is a bigger building. But by wall dominant, I was referring to the text of the redevelopment plan in 2C that guides design. Buildings should be designed to be wall dominated in that the roofs are visually less dominant in the total design. That is a guideline embodied in the redevelopment plan, and that was the context of my testimony.
And so the surrounding homes on Mine Street are more roof dominant than wall dominant, correct?
I don't have a particular opinion of the surrounding homes. Frankly, I haven't looked at the wall domination of those homes. And the language in the redevelopment plan is to guide new design, not to comment on that which is in the area.
So, I think you've answered my question. You testified initially in March that the proposed building at that time was compatible with the surrounding uses and buildings, correct?
In March, that was the prior design.
Yes.
I believe I testified that the treatment of the mass, or the treatment of what we were presenting at the time, was compatible in terms of its rhythms and scales. If I recall what I said correctly, if I recall correctly what I had said, it was talking about the treatment of how we articulated the facade.
No further questions. A few questions from Mr. Bowman.